Dear students, subscribers, and the viewers, welcome to the IAS Mentor. We are continuing our series on Indian polity. This would be our lecture number 48 in the series. Today we are going to take a very important topic, and the topic that we are going to discuss today is the doctrine of basic structure. So I will try to cover as much as possible today's lecture, but in case if you are not able to cover, we will continue that in the next lecture. It's a quite very important topic, and a lot of case studies, a lot of case laws has to be understood in order to understand as to what exactly is this doctrine of basic structure. So we'll try to understand all those things. So in the process of understanding the doctrine of basic structure, so first we'll have to try to understand what exactly is this doctrine of basic structure. Where is it mentioned in the constitution? Is it mentioned in the constitution in the first place? If not mentioned in the constitution, how it came about? So most of you might know that this doctrine of basic structure is merely a judicial innovation. It is nowhere mentioned in the constitution. So under what circumstance the judiciary was able to innovate this particular doctrine of basic structure? In fact, this continued, or the idea surrounding this doctrine of basic structure to it evolved by the judiciary. It happened in the Keshavananda Bharati case in 1973. But for this to come, a couple of decades the judiciary involved in answering a couple of questions. And ultimately in the end that resulted in what is called as the doctrine of basic structure. So we'll also try to understand as to what are all the various case laws that is surrounding, and that led to the innovation of what is called as the doctrine of basic structure. So we'll try to understand that also. And then what is the present position today? Is it the doctrine of basic structure continue to exist today? So we'll also try to understand that. And of course, what is the analysis of this particular doctrine of basic structure? There are pros and cons. There are people who favor this particular idea of doctrine of basic structure. There are people who don't favor this particular doctrine of basic structure. So we'll try to assess all those things as a part of this particular discussion. So before I proceed, what exactly is this doctrine of basic structure? So to put it in a very simple way, the doctrine of basic structure is an idea that is put forward by the judiciary in the Keshavananda Bharati case 1973. And what exactly is this idea? The idea is that in the opinion of the Supreme Court, the amending powers of the parliament, in the previous lecture we have talked about the amending powers, or how the constitution can be amended. And under Article 368, we have seen that this power is given to the parliament. That is exactly we have seen as to how it can be done. We have seen that amendment which is done by simple majority, amendment that is done by special majority, amendment that requires not only the special majority but also ratification by half of the states. But anyways, in all these cases, the power is given only to the parliament. So what is this doctrine of basic structure? This doctrine or this principle or this idea that is put forward by the judiciary, that is the Supreme Court, in the Keshavananda Bharati case in 1973, making it very clear the power of the parliament to amend the constitution is not unlimited. Rather, it is limited. So the simple idea is whether the power of the parliament to amend the constitution is unlimited or limited. In other words, if the power of the parliament to amend the constitution is unlimited, that means the parliament has authority to amend any provisions in the constitution, and therefore they can change the entire constitution tomorrow. Is that possible under the Constitution of India? Because it is a constitution that is giving the power to the parliament. So by using that power, can the parliament alter the constitution in totality? So that's a question that the Supreme Court has to answer in the Keshavananda Bharati case, where the Supreme Court has made it very clear that the power of the parliament to amend the constitution is not unlimited, rather it is limited. And to what extent it is limited? It is limited to the extent that the parliament does not have the power to take away the basic features in the constitution. So that's basically what was ruled by the Supreme Court. And who is supposed to determine as to what constitutes the basic features? It is for the Supreme Court to determine as to what constitutes the basic features in the constitution. So whatever is declared to be part of the basic structure or the basic features in the constitution, so those provisions cannot be altered by the parliament using its power under Article 368. That is not possible. Apart from the basic features in the constitution, or apart from those provisions which is not declared to be part of the basic structure, all other provisions can be amended. That is not an issue. That includes even the fundamental rights. Even the fundamental rights can be amended unless and until the fundamental right is not part of what is called as a basic structure. So this is exactly in crux what the Supreme Court has told in what is called as a Keshavananda Bharati case. In fact, they have given a lot of reasons to that. We'll try to understand all the reasons as well as we'll proceed. So if you ask me what is basic structure, to put it in a very simple way, basic structure is a principle that was innovated by the judiciary, and according to this particular principle, the power of the parliament to amend the constitution is not unlimited, it is rather limited. It is limited to that what extent? It is limited to the extent that the parliament does not have the power to destroy the basic structure of the constitution. Apart from the basic structure, they can amend the other provisions. That is not an issue. So this is basically what is called as a doctrine of basic structure. In fact, one major argument that was put forward is the parliament is nothing but a creature of the constitution, because the parliament is just one institution under the constitution. So the creature of the constitution cannot destroy the constitution. That's the idea. So it is a constitution that is giving the power to the parliament. By using that power, can the parliament alter the entire constitution? The Supreme Court believed it cannot happen. And therefore, they came out with the idea of what is called as the doctrine of basic structure, which we'll try to understand, elaborate, but it did not directly happen in 1973. For the Supreme Court to come to this logical conclusion, it almost took more than a couple of decades. A lot of litigations happened in a court of law. And then finally, all these things culminated, and then in the Keshavananda Bharati case, this judgment came. Okay. But before that, we'll have to understand the series of cases, and then we'll understand the series of cases, and then we'll also try to understand as to what are the pros and cons of this particular doctrine of basic structure and all those things as we'll proceed in the lecture. So first we'll have to understand how this doctrine of basic structure came, and for that the first case that you have to look into is what is called as the Shankari Prasad case in 1951. I would say even before Shankari Prasad case there was a case which is called as, we have already seen, the Kameshwar Singh case. That is even more important, and after the Kameshwar Singh case, a continuation of that is what is called as the Shankari Prasad case. Anyways, before going into all these cases, what basically we'll have to understand is, in fact, the entire doctrine of basic structure is nothing but an outcome. It is an outcome of the judiciary, wherein they declared that the power of the parliament to amend the constitution is not unlimited, rather it is limited. So that is what the judiciary has said. If you see the entire doctrine of basic structure, it is nothing but a power struggle between two organs of the state. On the one hand, it is a legislature, on the other hand, it is a judiciary. The legislature was trying to assert, when I say legislature, here is it is nothing but the parliament. The legislature was trying to assert its power to amend the constitution by way of Article 368. The judiciary is trying to assert its power through what is called as a power of judicial review, which also it derives it from the constitution. So on the one hand, the legislature is trying to assert its power to amend the constitution. On the other hand, the judiciary is trying to assert its power to review such actions of the legislature. And ultimately, this power struggle between the two organs of the state led to a logical settlement or a logical conclusion in the form of what is called as the doctrine of basic structure. So if you ask me that in this power struggle who had won this particular thing, so almost we can say the victory was somewhere in favor of what is called as a judiciary. So the judiciary, by innovating the doctrine of basic structure, they had an upper hand even today with regard to constitutionally reviewing certain constitutional amendments that is done by the parliament. Anyways, we'll try to understand as to how all these things have happened. But for me to understand all those things, first we'll have to go back to what is called as a Kameshwar Singh case. So even before I come to the Shankari Prasad case, there was a case which is called as a Kameshwar Singh case. Even in the previous classes, I have discussed about this particular case. But for the students who are newly watching this particular lecture, I'll discuss about this Kameshwar Singh case, 1951. If you see this Kameshwar Singh case, in fact, this case is an interesting case in the history of India, because after the commencement of the constitution, there are various governments, various state governments have come out with what is called as a Land Reforms Act or the Zamindari Abolition Act. So similar laws were enacted by various state legislature. And what is the objective of enacting these laws is to ensure what is called as social and economic justice, because you understand that social and economic justice is part of the directives in the directive principles of state policy. So various states wanted to bring in this reforms. So one such law was also enacted by the state of Bihar. So they came out with what is called as a Bihar Land Reforms Act. And through the Bihar Land Reforms Act, they were trying to take away the lands of the zamindars. So the zamindars' lands are to be taken away. And one such zamindar who was affected because of this particular Bihar Land Reforms Act is Kameshwar Singh. So he was a big landlord in the Darbhanga region of Bihar. So Kameshwar Singh did not like this, because through the Land Reforms Act, his lands are to be taken up by the government. So he challenges Land Reforms Act on the ground that it is violative of his fundamental rights. So in fact, what is the argument that he has put forward? That these Land Reforms Act is violative of Article 14, 19 and Article 31 of the Constitution. So this is the argument that he has made. So the Land Reforms Act that was passed by the state legislature of Bihar is violative of his fundamental right. And what is Article 13 of the Constitution is saying? If you go back to Article 13. So Article 13 is saying that if any law which is in violation of fundamental rights, then such law can be declared to be invalid. So Kameshwar Singh is saying that the Bihar Land Reforms Act is violative of my fundamental right, that is violative of my right to property. And he also said that it is violation of principle of equality also. We'll try to understand that. Therefore, these laws are liable to be struck down. This is what is the argument that was made by Kameshwar Singh. But whereas the government said, no, Kameshwar Singh argument is wrong, because the right to property at that point of time, try to understand, there was right to property. So because we have seen in our previous lectures also, the right to property continued to be a fundamental right till 1978. Only by the 44th Constitutional Amendment Act in 1978, the right to property was taken away. So all these facts should be there in your mind to understand this particular case completely. So, but this case happened way back in 1951 itself. So Kameshwar Singh argued that the Bihar Land Reforms Act is violation of his right to property. The state argued, no, Kameshwar Singh is wrong in his argument, although he exercised right to property as a fundamental right, but the right to property is not an absolute right. And why the right to property is not an absolute right? You go and look into Article 19 of the Constitution, because at that point of time there was one article, that is Article 19 Clause 1 Subclause F. So when I talk Article 19, it is specifically Article 19 Clause 1 Subclause F, which gave the right to every citizens to acquire, hold and to dispose of property. So the state said, yes, every citizens do have the right under Article 19 to acquire, to purchase a property, to possess that particular property and to sell that particular property. We agree that. But the right to property under Article 19 is not an absolute right, and they can be reasonably restricted. And one ground, in fact, there are two grounds on which they can be reasonably restricted. One is in public interest, two is in the interest of the scheduled tribe. So one is in public interest or public welfare. So the court, the state argued in front of the court, Kameshwar Singh argument is not right, because his right to property is not absolute, but rather his right to property can be reasonably restricted in public welfare. So they said that it can be restricted in the grounds of what is called as public welfare. And in fact, we are taking his property in public welfare. And apart from that, it is also not violation of Article 31, because Article 31 of the Constitution is saying that no person shall be deprived of his right to property except by an authority of law. That means the right to property can be taken away, and how it can be taken away, if at all, if it is taken away, it shall be taken away only by a law, and through that law, a due process has to be followed, a proper procedure has to be followed. So in this case, the state was making an argument, first thing, the right to property is not an absolute right, it can be taken away in public welfare. Secondly, if at all the right to property is taken away, we'll have to take it by way of a law. So we have enacted what is called as the Bihar Land Reforms Act, and the act provides for a procedure, and only as per that procedure we are taking away the property of Kameshwar Singh. So Kameshwar Singh argument is not valid, it is not violative of his right under Article 19 or under Article 31. But then subsequently Kameshwar Singh argued the state is right till this point of time, but what the state has failed to do is, while the state can take away my property in public welfare and it can be done by a way of a law, but it is also essential that I should be given a compensation whenever my property is taken away, and that compensation should be a fair, just and a reasonable compensation. So Kameshwar Singh said that I was not given any compensation, or the compensation is not fair. So therefore it is violative of my right to property under Article 19 and Article 31 of the Constitution, and the court has also accepted to this particular argument. The court said yes, the state can deprive an individual of his right to property in public welfare by way of a law, but while doing so, you will have to give a reasonable compensation. You will have to give a fair and a just compensation to the individual. And if you are not doing that, then it is violative of their right under Article 19 and Article 31 of the Constitution. And apart from that, Kameshwar Singh also said, looking into this particular law, the Bihar Land Reforms Act, it is giving a lot of discretion to the state or the law enforcement authority to provide different compensation to different people whenever their property is deprived. So therefore, it is also a violation of principle of equality. So it goes against the essence of equality in the Constitution, and therefore it is violative of Article 14 as well. So Kameshwar Singh was able to convince the court that this action of the state was violative of Article 14, 19 and Article 13. Article 14 because there was no equality in terms of compensation. Article 19 and Article 31 because the compensation was not just and fair. Although it was in public welfare and although it was by way of a law, but the compensation, just because it is not just and fair, this action of the state is violative of the fundamental rights. So the court was convinced that it is in violation of the fundamental rights. And therefore, it was a big blow to the government. It was a big blow to the government agenda of ensuring the social and economic justice. So now if one such law is declared to be so by the Supreme Court, the same judgment can apply to the other actions of the state as well in the future. So somehow the state has to overcome all these obstacles. And to overcome all these obstacles, the state brought in, or I would say the parliament enacted the first Constitutional Amendment Act. In fact, it was to nullify the judgment that was given by the Kameshwar Singh case. They enacted 2 articles into the part 3 of the Constitution. After the Kameshwar Singh judgment, they brought in what is called as Article 31A and Article 31B. These 2 articles were inserted into the Constitution by the first Constitutional Amendment Act in 1951. So we already elaborately discussed about Article 31A and Article 31B. I've done a separate video on Article 31A, 31B and 31C. So for the students, for a detailed understanding, you can go and watch that particular video, 31A, 31B and 31C. But here also for the continuity, I'll summarize that very briefly. So what is Article 31A? So which is result of the Kameshwar Singh case. So it was all inserted by the first Constitutional Amendment Act, as I already said. What is Article 31A? Article 31A saves certain categories of laws, especially related to agrarian reforms, especially related to acquisition of estates and the management of those estates by the state. If any law is made by the state intending to bring in agrarian reforms, that is land reforms, intending to acquire estates are nothing but large tracts of land which are given to big landlords, and thereby giving them certain rights to collect taxes and all those things, which was done by the Britishers. Initially, the Britishers gave a lot of lands to certain landlords and therefore allowed the landlords to cultivate those land and pay taxes to the government. So such system continued or practiced even after the commencement of the Constitution also. So if at all the state is making any law where it is trying to make land reforms, where it is trying to abolish zamindari system, where it is trying to acquire the estates and the way the estates are to be managed, if there is any law that is brought in all these areas, and even if these laws in these areas, the said areas, not in the other areas, in these areas, if the law is found to be violative of Article 14, 19 and Article 31, still it cannot be challenged in a court of law. So Article 31A was majorly aimed at protecting certain categories of laws, especially related to acquisition of estates, land reforms and all those things. And if these laws, even if they are violative of which laws, even if they are violative of Article 14, 19 and Article 31, they cannot be challenged in a court of law. So they state that it is a good protection in the future, that they don't have to encounter and they don't have to face the challenges what they have faced in the Kameshwar Singh case. So this is why Article 31A was inserted into the Constitution. But they did not stop there. But they also thought the laws could be challenged on the other grounds also, not necessarily in Article 14, 19 and Article 31, because Article 31A is providing protection only against fundamental right 14, 19 and 31. But what if it is challenged on other fundamental rights or any of the other provisions in the constitution. So in order to prevent that, they also brought in one more article, that is Article 31A. And if you see this Article 31A, Article 31A saves the law from being judicially reviewed. That means Article 31B allows for what is called as the 9th schedule of the Constitution. So let me just take a moment to explain this. Article 31B says that if any law is placed inside the 9th schedule, that law which is placed inside the 9th schedule will be completely immune to judicial review. That means it cannot be challenged at all. So that is the idea of Article 31B. So by bringing in Article 31B, they also brought in a new schedule into the Constitution, that is a 9th schedule, and this is also many times asked in the examination. Which amendment or through which amendment the 9th schedule was brought in? It was by the first Constitutional Amendment Act 1951. So that means Article 31B saves the laws placed inside the 9th schedule completely, or the laws placed inside the 9th schedule is having blanket immunity from what is called as judicial review. That is Article 31B. So the difference between Article 31A and Article 31B is, while Article 31A protects only certain categories of laws related to agrarian reforms and all those things, and only against Article 14, 19 and Article 31. Whereas what is Article 31B? Article 31B is saying that if any law is placed inside the 9th schedule, and that law would be completely immune to judicial review, blanket immunity from judicial review. So here any category of law, complete protection against being judicially reviewed, but the condition is this law has to be placed inside the 9th schedule. Unless and until it is placed inside the 9th schedule, so nothing will happen. So that's the basic understanding you should have. All right. Now, with these two changes in the Constitution, the government thought that now they are well placed to ensure what is called as a social and economic justice in the society. So now the government had some element of relief. So probably they thought either I'll protect the laws under Article 31A if it is against Article 14, 19 and Article 31, or if I want blanket immunity, I will amend the Constitution and I'll place the law inside the 9th schedule. And thereby there will be a blanket immunity. So they were having some relief, so that in the future the measures that they take to ensure social and economic justice may not face any scrutiny in the judiciary, or they can escape the judicial scrutiny. But however, what happened, there was one zamindar again in the state of Bihar, Shankari Prasad, and this Shankari Prasad was not happy with the first Constitutional Amendment Act because some of his properties might be taken away. He is again a landlord. So he thought that if Article 31A and Article 31B continue to exist, using that they may take away my property. So what Shankari Prasad has done is Shankari Prasad challenged the validity of the first Constitutional Amendment Act in the Supreme Court. So what is a major question in the Shankari Prasad case is that they have to determine the validity of the first Constitutional Amendment Act. Is the first Constitutional Amendment Act valid? So that is basically the court has to decide. So when I say whether the first Constitutional Amendment Act is valid, first Constitutional Amendment Act, within first Constitutional Amendment Act, they wanted to see the validity of Article 31A and Article 31B. That's the only thing that was challenged. So he challenged Article 31A and Article 31B is invalid. And only if Article 31A and Article 31B is valid, then only the laws can be made. Then only they can place a law inside the 9th schedule. So basically, Kameshwar Singh challenged the validity of the first Constitutional Amendment Act itself. And for that, he also gave the reason. So what is the reason that he has given? So he has given the reason. See, look into Article 13 of the Constitution. What is Article 13 of the Constitution? So once you understand the Shankari Prasad case, your entire understanding of doctrine of basic structure will be clear. But if you don't understand the Shankari Prasad case, your understanding of doctrine of basic structure is going to be extremely difficult. So try to pay some attention. So far we have understood the Kameshwar Singh case. Now we have come to what is called as a Shankari Prasad case. So in Shankari Prasad case, Shankari Prasad was challenging the validity of the first Constitutional Amendment Act, that is the validity of Article 31A and Article 31B are to be questioned. So what is the argument that was put forward by Shankari Prasad? Now Shankari Prasad is saying, so look into Article 13 of the Constitution. What is Article 13 of the Constitution is saying? Article 13 is saying that if any law is violative of fundamental right, if it is violative of fundamental right, then those laws can be struck down. It can be struck down. So this is what is Article 13 is saying. So Shankari Prasad is saying, if any law is violative of fundamental right, and therefore if it is found to be violative of fundamental right, they can be struck down by the courts. So that is the crux of Article 13. So look here, the first Constitutional Amendment Act is also a law, and by which they are inserting two articles, that is Article 31A and Article 31B. So the first Constitutional Amendment Act should also consider to be a law under Article 13, and if they are found to be violative of the fundamental rights, then they should also be declared to be invalid. So this is what is the argument he is making. That means basically Shankari Prasad is trying to say to the court that a constitutional amendment is also a law under Article 13. And if a constitutional amendment is also a law under Article 13, even by a way of a constitutional amendment also, you cannot take away the fundamental rights. So because any law which is in violation of the fundamental rights would be declared to be invalid. So because Article 13 is giving primacy to the fundamental rights, so no law should be inconsistent with fundamental rights, or no law should be in violation of fundamental rights. And if they are found to be violative, then they can be declared to be invalid. So this is the basic question that he brought in front of the Supreme Court. So now the court has to argue, now the court has to decide whether a constitutional amendment is law under Article 13. In fact, Shankari Prasad went ahead and he said, first of all, there is no power to the parliament to amend the fundamental rights. First of all, he said, there is no power to the parliament to amend the fundamental rights. And then he said, even if the parliament has a power to amend the fundamental right, that can be done only by a constitutional amendment. And that constitutional amendment is a law under Article 13. And if it is found to be violative of fundamental rights, it has to be declared to be invalid. So I'm just repeating these two questions again, because the entire argument that you are going to see with regard to doctrine of basic structure will revolve around only these things. So what is the first thing that Kameshwar Singh is saying? Kameshwar Singh is saying that the parliament has no authority or no power to amend the fundamental rights, because the first Constitutional Amendment Act, which inserted Article 31A and Article 31B, was brought in only by amending the Constitution, only by amending the fundamental rights, to be very specific. So he is saying the parliament has no authority to amend the fundamental rights. And if the court is convinced of this, then the matter is over there, and they will declare Article 31A and Article 31 to be invalid. Now the second thing that he is saying is that it is not only that the parliament does not have the power to amend the fundamental rights. If they amend the fundamental rights, and therefore by amending the fundamental rights, if they are violating any of the other fundamental rights, and therefore those amendments should be declared to be invalid. Because he is quoting Article 13 of the Constitution, which is saying that any law which is in violation of fundamental rights would be declared to be invalid. So the second question is, the court has to decide is whether a constitutional amendment is a law under Article 13. So basically, after all these arguments, two questions that the Supreme Court has to decide. So what are the two questions that the Supreme Court has to decide in this particular cases? So first is, does the parliament has the power to amend the fundamental rights? I am repeating it, does the parliament has the power to amend the fundamental rights? Does the parliament has the power to amend the fundamental rights? That's the first thing, or that's the first question that you have to understand. The second question is a constitutional amendment, or does a constitutional amendment a law under Article 13? Is a law under Article 13. So these are the two questions that probably that the court has to answer. So I'm just repeating the question again. What is the first question? Can the parliament amend the fundamental rights? If yes, the matter is resolved. But however, the second question is putting it is that even if the parliament has a power to amend the fundamental right, and that would be considered to be a law under Article 13, and by that amendment, if they are taking away any of the other fundamental rights, then also it should be declared to be invalid, because Article 13 is saying no law in violation of fundamental right shall be considered to be valid. Okay, that is what is Article 13. So he is trying to convince the court by a constitutional amendment, that is by inserting Article 31A and Article 31B, they are trying to take away my other fundamental rights like Article 14, 19 and Article 31. So therefore, this first Constitutional Amendment Act should be declared to be invalid under Article 13 of the Constitution. So now the court has to answer both these questions. Does the parliament has a power to amend the fundamental rights? In fact, the court was convinced After all the arguments, the court found yes, the parliament has the power to amend the fundamental right. And what was the reason that was given by the court? The court was giving this particular reason. If you look into the constitution gives the parliament two types of powers. This is what is their opinion. So as per the constitution in the Shankari Prasad case, the parliament is having two types of powers. What are the powers? One is the constituent power and other is the ordinary powers or ordinary lawmaking powers. Ordinary lawmaking power and other is the constituent power. So these are the two types of powers that is given to the parliament. And this constituent power is coming under Article 368. Article 368 is giving the constituent power to the parliament, and outside Article 368 a number of other provisions in the constitution, they do give what is called as the ordinary lawmaking powers. So basically the entire argument of Shankari Prasad was resting upon these two arguments. What is the argument? That the parliament under the constitution has got two types of powers. One is the constituent power, which is coming to the parliament under Article 368. And other is what is called as ordinary lawmaking power, that is outside the scope of Article 368. And what is the Supreme Court further saying? So this constituent power is similar to that of the power exercised by the Constituent Assembly. So before the constitution came into force, there was a Constituent Assembly, and the power of the Constituent Assembly is to draft the constitution. So once the constitution was drafted and then it came into force, this constituent power was given back to the parliament by the constitution under Article 368, which means under Article 368, the parliament which exercise the constituent power have the power to amend the fundamental rights. In fact, they have the power to amend any provisions in the constitution, including the fundamental rights. So the court was convinced that the parliament has got the power to amend the fundamental rights. So the first question is answered. So that means for the first question, Shankari Prasad has lost his argument. Does the parliament has a power to amend the fundamental right? Yes, because under Article 368, the parliament is given the constituent power by the constitution. By using this constituent power, they can amend any provisions of the constitution, including the fundamental rights. So can the fundamental rights be amended? The Supreme Court was convinced because the court has got what is called as the constituent power. So this is answered. And further, the Supreme Court was convinced, but the court, the constitution is not only giving the constituent power to the parliament, but it is also giving what is called as ordinary lawmaking powers. So ordinary lawmaking powers means to make ordinary laws. Constituent power means to amend the constitution. So now, once they have segregated that the parliament has got two types of powers, now the Supreme Court is coming to the next question. Can a constitutional amendment be considered to be law under Article 13? So this is the next question that the court has to argue, or the court has to find out. Shankari Prasad was making an argument that a constitutional amendment is a law under Article 13. And if this argument is to be accepted, that means if any law is in violation of fundamental right, that law should be declared to be invalid under Article 13. Now the question is whether a constitutional amendment is a law under Article 13 or not. This is what the court has to see. And to arrive at that particular question, the court has rested upon these things as well. Because the Supreme Court was convinced there are two types of powers under the constitution to the parliament. One is the constituent power, another is the ordinary lawmaking power. Under the constituent power, they can amend the constitution, any provisions including the fundamental rights. And then they have ordinary lawmaking power outside Article 368 through number of other provisions in the constitution by which they can make the ordinary laws. By resting upon this principle again, the Supreme Court said what would be considered to be law under Article 13 is only the ordinary laws which is made by the parliament. And a constitutional amendment which is done by the parliament using its constituent power is not a law. It is not considered law under Article 13. It is not to be considered law under Article 13. Under Article 13. So what is to be considered to be law under Article 13 is only the ordinary laws which is made under Article 13. So that means the Supreme Court is convinced if any ordinary law is made, and by that law if there is a violation of any fundamental right, those ordinary laws can be declared to be invalid under Article 13, but not a constitutional amendment, because a constitutional amendment is not to be considered law under Article 13. And therefore, by using a constitutional amendment, you can take away any of the fundamental rights. But you cannot take away the fundamental rights by using an ordinary law, because an ordinary law is law under Article 13, but not a constitutional amendment. So this was a judgment that was given by the Supreme Court in the Shankari Prasad case. So I think it is quite clear to all of you. By making both these arguments, the Supreme Court upheld the validity of Article 31A and Article 31B, or they upheld the validity of the first Constitutional Amendment Act to that extent. And that was a big victory to the government and of course the legislature. So that means the Supreme Court has made it very clear two things. One, after the Shankari Prasad case, the first thing is the Parliament does have the power to amend the fundamental rights. So that question is very clear. And if at all any constitutional amendment is made, will it be considered to be law under Article 13? The Supreme Court said no. A constitutional amendment is not a law under Article 13, because a constitutional amendment is done by using the constituent power which is given to the Parliament under Article 368. They would not be considered to be law. And what would be considered to be law under Article 13 is only the ordinary law that is made by the Parliament. And hence, if an ordinary law is violative of any of the fundamental rights, they can be declared to be invalid under Article 13, but not a constitutional amendment, even if it is taking away a fundamental right, is not a law under Article 13. And hence, those amendments cannot be challenged on the ground it is violative of fundamental right, because a constitutional amendment in the first place does not fall within the definition of law. So this has been made clear by the Supreme Court. That means after all these arguments, Shankari Prasad has lost his case. So this was a big victory to the government, and they were very happy because they can continue proceeding with what is called as their socio-economic justice, and they can bring in all these reforms, including the land reforms, acquisition of private properties and all those things, because all their actions would be protected either under Article 31A and Article 31B, and which was done by the first Constitutional Amendment Act, and they were upheld by the Supreme Court. Now things continued further, and the same matter again became part of the judicial scrutiny in a case which is called as the Sargent Singh case in 1964. So this time the issue was related to a law that was enacted in the state of Rajasthan. Sargent Singh versus state of Rajasthan. So what happened in this particular case? In fact, in this particular case, what was challenged in the Supreme Court is the first and the 17th Constitutional Amendment Act. So first and the 17th Constitutional Amendment Act was challenged in the Supreme Court. And what was the reason as to why these amendments were challenged in the Supreme Court? First, the Constitutional Amendment Act, because it provided for what is called as Article 31A and Article 31B. And it was this Article 31B which allowed for what is called as the 9th schedule in the Constitution. The 9th schedule in the Constitution is by virtue of the first Constitutional Amendment Act, or Article 31B. And what is the 17th Constitutional Amendment Act? If you see the 17th Constitutional Amendment Act, at that point of time, some Land Reform Act was passed in the state of Rajasthan, similar to that of the Land Reform Act in Bihar. Some Land Reform Act was placed in Rajasthan. But this Land Reform Act, which was passed in the state of Rajasthan, this Land Reform Act was placed inside the 9th schedule. Now you understand that under Article 31B and 9th schedule, any law which is passed, if it is placed inside the 9th schedule, it will have what is called as complete immunity or blanket immunity. So in order to provide the land reforms, the immunity which was passed by the state of Rajasthan, and to provide immunity to this particular law, this law was placed inside the 9th schedule by amending the constitution. The Rajasthan state has passed this law and requested the parliament to amend the constitution and to place the law inside the 9th schedule. And this law was placed inside the 9th schedule by the 17th Constitutional Amendment Act. And what is the relation to Sargent Singh in this particular case? Because he was in the state of Rajasthan, this Land Reforms Act was trying to take away the properties of the landlords in state of Rajasthan. And that law was placed inside the 9th schedule. So therefore, it cannot be judicially challenged. It cannot be judicially reviewed. So Sargent Singh was not happy with the 17th Constitutional Amendment Act, which gave judicial immunity to the Land Reforms Act. So basically he challenged the entire constitutional amendment itself is invalid. So for that he has to also challenge the first Constitutional Amendment Act, because the law is placed inside the 9th schedule, and the 9th schedule comes from Article 31B, and 31B was inserted by the first Constitutional Amendment Act. So he basically challenged both the first constitutional amendment as well as the 17th Constitutional Amendment Act. So here also he made the same argument that the parliament does not have the power to amend the fundamental rights. And then a constitutional amendment is a law under Article 13 of the Constitution, and hence any law, be it even a constitutional amendment, should be declared to be invalid if it is violative of the fundamental rights. The same argument was made by Sergeant Singh also, but the Supreme Court did not accept this particular argument. Again, the Supreme Court ruled in favor of the state, or whatever the judgment which was given by the Shankari Prasad case was almost ruled by the Sergeant Singh case also, wherein they were convinced that the parliament has a power to amend the fundamental rights by using what is called as a constituent power. In fact, they have said that the parliament has no limit in terms of what they can amend. So by using their constituent power under Article 368, they can amend any provisions in the constitution. In fact, they explicitly use the word unlimited powers to the parliament. And then they also said that a constitutional amendment would not be considered to be law under Article 13, and hence a constitutional amendment, if it is taking away any of the fundamental rights, it cannot be challenged under Article 13. Again, a big blow to Sergeant Singh also, Shankari Prasad also. So Zamindars after Zamindars, they lost the case, and it was a big victory to the government and to their socio-economic reforms agenda. So this is what has happened in the Sergeant Singh case. So that means by the Sergeant Singh case, it was very clear that the parliament was having unlimited powers to amend the constitution, including the fundamental rights. But even in the Sergeant Singh case, there was one minority judgment. Minority judgment means in a constitutional case, usually 5 judges will be there. And sometimes not necessarily all the 5 judges will agree on the same thing. But even if 3 judges out of 5, probably if they decide on certain basis, that is the majority judgment. So even in the Sergeant Singh case, there was one minority view that if you give unlimited powers to the parliament, that it is very dangerous. And by using this unlimited power, tomorrow the parliament can change the entire constitution. What if the constitution is amended by the parliament to the extent that India is not a democratic country? So unlimited powers to the parliament means very dangerous. So this thought of the minority judgment which was given by one of the judge was the starting point in our country, which led to what is called as the Doctrine of Basic Structure, which later restricted the powers of the parliament to amend the constitution, which you will subsequently understand. But if you see, till this point of time, the Zamindars were losing the case. That is, Shankari Prasad lost the case, Sergeant Singh also lost the case. But then came what is called as the Golaknath, again a big landlord from the state of Punjab. So this time, the landlords from Bihar and the landlord from Rajasthan, while they lost the case, but a landlord from the state of Punjab reversed the entire judgment. And he completely changed what was held by the Supreme Court by having a different line of argument. And that came to be what is called as the Golaknath case. So let us try to understand what happened in the Golaknath case, but I'll do it in the next class. In the next class, we'll try to understand what happened in the Golaknath case, and then subsequently what was held in the Shankari Prasad case, and also what is the present status of what is called as the Doctrine of Basic Structure. But to understand that, you should also have a proper understanding of what I have discussed till this point of time. So let me just recap what we have discussed till this point of time. Now the starting point of the basic structure is because of the struggle between the legislature and the executive. The legislature and the judiciary. The legislature was trying to assert their power to make the laws and to amend the constitution, where the judiciary was trying to use their power of judicial review. So this clash led to what is called as innovation of Doctrine of Basic Structure, which started in what is called as the Kameshwar Singh case. And then subsequently, to nullify the judgment which is given by the Kameshwar Singh case, first Constitutional Amendment Act was inserted, and Article 31A and Article 31B was inserted. And then subsequently, the first Constitutional Amendment Act was challenged in the Shankari Prasad case, where the Supreme Court categorically held that the Parliament has a power to amend the fundamental rights, and a constitutional amendment is not a law under Article 13. And what is law under Article 13 is only the ordinary law. So big blow to Shankari Prasad. Then the same matter was challenged in the Sergeant Singh case. In the Sergeant Singh case, the Supreme Court further used the word that the Parliament has got unlimited powers to amend the constitution, by which they can also amend what is called as the fundamental rights. And of course, a constitutional amendment is not a law under Article 13, and hence By a constitutional amendment, if the fundamental rights are taken away, then there is no remedy. By an ordinary law, if a fundamental right is violated, then they can be struck down under Article 13. So two things has to be very clear till this point of time, till the Sargent-Singh case, that the first thing is the parliament has the power to amend the fundamental right, or in fact the parliament has unlimited powers to amend the constitution. Two, that a constitutional amendment is not a law under Article 13. That means by a constitutional amendment, if any of the fundamental rights are taken away, they cannot be challenged in a court of law. If an ordinary law is violating any of the fundamental right, then that can be challenged in a court of law under Article 13. So these are the two things that has been clear till this point of time. But what was the argument that was made by the Golaknath in 1916 that led to the reversal of this particular judgment is something very interesting argument. But we'll see what the Golaknath brothers, the landlords from the state of Punjab, how they made an argument and how they got the entire judgment reversed in the Golaknath case. Is an interesting case which we'll discuss in the next class. If you have any queries or any questions related to this particular lecture, you can reach out to me. You can reach out to me either through my Instagram account or through my Telegram channel. And not only related to this particular lecture, any lecture, if you have any doubts related to the exam, you can reach out to me. I know that the students who are usually preparing for the first time, they'll have a lot of doubts in their mind. And it is better to reach out to the people rather than making the mistakes and learning from it, because I know that people who are usually doing it for the first time or the first generation will face a lot of difficulties as I have faced during my preparation phase. So please do reach out. And also one small request, if you know any of your friends or family members preparing for UPSC IAS examination or other competitive examination, you can refer them this channel and this particular video as well. And in fact, this entire series as well, and of course other programs that you are going to do, and I'm quite sure it is going to be immensely beneficial to the students preparing for the competitive examination. Thank you very much. Keep watching. All the best.